Hi there, thanks for joining us today. We're coming to you live from REDDY NEUMANN's office in Houston, Texas. My name is Emily Neumann, and with me is one of our partners and Senior Practice Manager, Rebecca Chen. Thanks for joining us today, Rebecca. So we wanted to give you, as usual, every Tuesday at 5 o'clock Central Time, we give you the latest immigration updates, and of course we'll answer your questions on everything that's going on right now. So Rebecca, what do you have for us today?
Yeah, so the big thing in the news this week is the announcement yesterday concerning kind of the fate of the F-1 international students, which we've kind of wondered about on these sessions before, and the SEVP came out with their temporary guidance yesterday. So that has kind of stirred up a lot of controversy because it's not great news for most international students or the universities. We will also talk a bit more about the potential furlough of USCIS employees, which is slated to start next month unless USCIS can reach an agreement with Congress for the emergency funding they've been asking for since May. We'll also talk a bit about DACA, the Deferred Action for Childhood Arrivals program, how the administration is planning to proceed after the Supreme Court decision on those cases last month, and also when we expect to see biometrics and in-person USCIS interviews start again, since so far that hasn't happened despite USCIS's announcements that they would resume last month. So starting with this F-1 announcement, Emily, so what is this guidance from SEVP that came out yesterday?
Right, so with very little notice, I mean, we've got fall classes starting soon, and many universities have started announcing what their fall semester is going to look like, whether it's going to be online, in person, or a hybrid between the two. And SEVP came out yesterday and said basically that F1 students will not be permitted to take an all online course load, which that has generally been the rule all along, that you're limited in your online options and you have to choose face-to-face options, but that also was not during a pandemic. So they're basically saying that if the F1 student is planning to enroll in classes in the fall, that all their classes will be online, that they won't be able to do that. They won't be able to maintain status. So they either have to leave the United States or not come in to begin with, or find another school that will provide them with in-person classes. So at this point it's really unfair to the schools and the students. Number one, it's very last minute. Most programs are starting a month from now, and it's forcing schools to decide between safety of their students versus being able to accept international students, which for many universities and colleges and even community colleges in the United States, they have a large international student population, and that's a large portion of the tuition that they bring in. So what are your thoughts on what students should be doing right now?
It is really hard to say. I think the students and schools are kind of scrambling right now to figure out what's going on. Obviously, for anyone who is planning to come in as a first-time F1 student, or who is outside the U.S. now and was planning to come in on an F1 visa, as you probably know, the consulates are still for the most part closed. So for new international students coming in, it looks like that will depend on your consulate reopening. But for students who are here in the US in F1 status already, probably the first thing I would try to figure out is whether the school that you are enrolled in now is what their plan is for the fall semester. Are they going to be online only? Are they going to be this hybrid model where they will be partially online and partially in person, hopefully with some safety precautions? Or will they be entirely in person? So the SEVP guidance yesterday provided for basically those three scenarios and how much online classes students in those three scenarios are allowed to take. Basically, it sounds like in the hybrid model, they may be allowed to take more than the 3 credit hours that are in the regulations currently, but the SEVP guidance doesn't say how much more. All we know for sure is that according to that guidance, entirely online courses will not be eligible for F-1 students, at least for this school year. So that would be the first thing I would do as a student, is to try to find out from your school what their plan is for the semester. That may even be difficult. The schools are probably figuring that out themselves at this time. I mean, just recently there have been announcements from some of the universities on what their plans are. I believe the schools themselves, the international student offices, have until July 15th, which is not very far from now, to certify to the government what kind of model they are planning to have for the fall semester. So it seems that by at least July 15th, the schools will have to give the government an answer, so they should be able to give the students an answer by then on what kind of model they are planning to have.
All right, so yeah, lots of things are kind of in flux right now. We don't have a whole lot of specifics or answers. A lot of it will be depending on what the schools ultimately decide. But if the program is 100% online, they made it clear that you've got to start looking for another school, basically, and start the transfer process to join another school, which is very late to do, to go through the admissions process. So I would just be very cautious of that. If that's what you're looking to do, is move to a different school in order to be in compliance. Just be careful what school you pick. You know, we talk time and again about so-called day one CPT schools, and that we don't recommend them, and that these are the schools that provide practically immediate admission into their programs. They're really easy to get in. There's no GRE, there's no TOEFL, there's no, you don't even have to give transcripts. Those are the kind of schools that really could profit from something like this, and you know, I hate to say prey on international students that are in a jam, but that's very possible. So please use caution. Again, we don't recommend those kind of schools. You know, stay away from that kind of situation and just be smart about it. So, you know, we've been hearing rumors, and now we're seeing emails that were sent to USCIS employees letting them know they're about to be furloughed next month because of budget issues. How do you think that, if this furlough actually happens, how is that going to impact people who are here and filing applications? What applications might it impact? What are your thoughts on that?
Yeah, so it could affect kind of the whole range of applications that USCIS processes. You know, the common ones that we talk about in these sessions are the I-129, I-539 applications, I-765 applications, many of which are already experiencing large backlogs at most service centers right now. I mean, we can only imagine that a furlough of over 13,000 USCIS officers is just going to add to those backlogs and delays. Yeah, it really is a difficult situation. It sounds like the agency and Congress are kind of at a standoff right now. It's hoped that they will reach some kind of agreement by the end of the month, and we know that in a lot of these sort of furlough situations, the Congress does sort of leave it to the very last week or even day sometimes before passing something to avoid a furlough, and so hopefully that's the case. But if there is a furlough, I mean, we can only imagine that there will be delays, more delays than what we're seeing now in processing applications. We don't know if premium processing may be taken away again, possibly. It was just reinstated last month. For most application types, it is available again now. It may be difficult for USCIS to guarantee a 15-day processing clock if their workforce is slashed by that much.
Yeah, so, you know, a few things to keep in mind if we're experiencing longer processing times. Number one, this is USCIS application, so it should not be impacting PERM processing or LCA processing. Those are done by the Labor Department. But generally, with employment-based immigration, once you file an application, if it's timely filed, that puts you in a period of authorized stay where you can remain in the U.S. based on the pending application. So if you're filing an H-1 extension or an L-1 extension and we're experiencing long processing times, as long as it was timely filed, you can continue working and remain in the U.S. based on the pending application. That work authorization, if it's an extension of stay with the same employer, does end after 240 days after the I-94 expires, so hopefully processing times won't get that long. So if you're expecting that to happen, maybe consider and work with your employer to file earlier rather than later, so that you can buy more time to deal with the longer processing times. For H-4, L-2 dependent applications, when you file that extension of status, there is no 240-day rule, so as long as it's timely filed, those people can remain in the U.S. based on the pending extension as long as it remains pending. For those that are filing a change of status to F-1, I think that's going to be a huge impact. We're already having to have people file these B2 bridge applications to continue to maintain some non-immigrant status while waiting for the F-1 to be approved. So that doesn't change, but the processing times might get worse. You may need to file 2 or 3 bridge applications. Again, hopefully this is all temporary. Hopefully it's all cleared up before it ever actually happens. Hopefully Congress will intervene, but just keep those things in mind when we are dealing with long processing times. Premium might not be available, but timely filed applications do allow you to generally stay in the country while you wait. So, the Supreme Court recently ruled that the way the Trump administration was trying to end the DACA program was not proper, so it temporarily is allowing the program to continue. But it sounds like the Trump administration wants to try again at ending the program. So what are you expecting to happen there?
Yeah, so even the USCIS update to its website after the Supreme Court decision was not very promising. USCIS itself said that the DACA program was illegal in their opinion, and so the administration is clearly still planning to eliminate the program. As the Supreme Court decision noted, it wasn't making a determination on the validity of the program itself, but whether the administration had gone through the proper procedures to try to eliminate it. And so it sounds like the administration is going to try to go through the right procedures, maybe provide more justification or more basis for its reasoning in eliminating the DACA program. So how that will play out, we'll need to see. But for now, it looks like the agency is still not accepting new DACA applications, even though a certain reading of the Supreme Court decision could, lead you to believe that it should be accepting new applications. Right now, it's not. So we'll have to see if the administration proposes additional measures to further try to eliminate it.
Do you think that this decision and what the next steps are going to have any impact on how the administration deals with the H-4 EAD and their plans to eliminate it?
Yeah, so the DACA kind of saga, how we've seen it move through the courts, is a bit indicative of how the H-4 EAD may be treated also. We've known since 2017 also that the administration has been wanting to eliminate the H-4 EAD. The Supreme Court decision is kind of promising in that sense, since it did seem to indicate that the Supreme Court is going to hold the administration to a higher standard when elimination of a work permit is going to affect individuals who are here in the U.S. and who are relying on the existence of the work permit for their employers as well, who are relying on the existence of the work permit. So that does give some hope that it'll be a higher scrutiny applied to the administration when it does try to eliminate the H-4 EAD. I don't know, what do you think?
Yeah, I think that perhaps they're going to have to come up with stronger reasoning why they intend to eliminate it, make sure they go through the exact proper Administrative Procedures Act step-by-step process, notice and comment rulemaking in order to eliminate it, so that they have to actually take into account people's comments throughout the process, and then give a justification why they still decided to go ahead with it. So the Supreme Court decision, I think, is helpful in that it makes it, I think, more difficult for the administration to eliminate the H-4 EAD. One of the huge issues we've had with this COVID-19 pandemic is the lack of biometrics appointment notices since March, and the lack of USCIS interviews at local offices, which are generally for the green card and naturalization process. So do you have an update on what's happening now with those offices? Are they reopening?
Yeah, so the most recent update from USCIS is that the ASCs, the Application Support Centers, which process the biometrics appointments, are expected to start a phased reopening July 13th. So people may start seeing biometrics notices in the mail in the next couple of weeks for fingerprint appointments. I would expect that the first ones that go out would probably be for appointments that were initially canceled back in March and April when the pandemic first was shutting everything down. And so for more recent applicants, it may be quite a bit longer until you see your actual fingerprint notice. But if it does take longer than usual, be aware that that's probably why there's a lot of backlogged or canceled appointments they'll need to get through first. They've also mentioned that they are obviously, for safety reasons, spacing out appointments, allowing fewer people into the buildings at a time, and so that's also going to slow down the process when they can't process as many people per day. So unfortunately, that's just another delay in the I-539 processing on the biometric side. For USCIS interviews, it sounds like that will be more on a field office by field office basis, based on the local situation. I know in the Houston field office, they have restarted some naturalization ceremonies in a limited capacity. They're also restarting some of the in-person interviews for I-485 and N-400 applications, but it seems like each city's field office is kind of deciding its own rollout and phased reopening in that way. So just be on the lookout for your appointment notice and make sure you review the guidelines on that new appointment notice. There are expected to be pretty specific instructions that everyone will need to follow to maintain social distance and all of that for safety reasons.
Do you know, in our office, have we received any rescheduled biometrics appointment notices yet?
I am not aware of any.
Yeah, I haven't seen any either. So, you know, we still really are just at the beginning of this reopening process, so it's certainly going to take more time, unfortunately. I guess we can get to some questions now. Let's see here. VJ from YouTube asks, a common question that we're seeing is any news on whether there's going to be a second round in the H-1B lottery. No information on that. You know, I think I'm not hearing of very many people that were selected and did not file. I mean, it does happen, but I think for the most part, the ones that were selected, the employers continued with the filing of the application. And at the same time, USCIS normally selects more than what they need to fill the lottery, because they know a certain number eventually either won't file or might get denied or might get revoked or all those sorts of things. So, you know, at this point, is there any possibility of a second lottery? Yeah. How likely is that to happen? I'm not seeing it very likely yet.
Saranya from YouTube is asking, in light of the SEVP guidance and the additional restrictions on F-1 students or kind of modified restrictions on F-1 students now. She is in F-1 status now and is thinking to change status to H-4 because her husband is in H-1B status, and is asking whether that's advisable. I would say that is probably a good idea. Unless you were, really counting on getting an OPT work authorization, or we're nearing the end of your degree program and are close to applying for the I-765. Yeah, given the uncertainties surrounding the F-1 situation right now, if you can change status to H-4, that would probably be a good idea to go ahead and file that I-539 application.
The Mooley from YouTube is doing a master's degree in the U.S. and has just one course left for the fall, but unfortunately that course has been switched to an online class and wants to know what the options are. I see in your situation you can't really switch to another school because it's a very specific subject that you're in, may not be available everywhere. At this point, if that class is only available online, you may have to register for some additional classes that are in person in order to be able to maintain your status, because they do allow some online classes. It just can't be all online classes. So hopefully you'll be able to find some other courses, even if it's something that you don't exactly need, but at least to be able to maintain your status under this new guidance. But certainly check with your school, the DSO's office, to see what they're recommending. I'm sure they are super busy right now, so give them some time to get through all this. Give you some more advice on that.
Yeah, so DACA has sort of a similar question. If my school is on a hybrid model, can we register for more than one online class or more than 3 credits? According to the guidance that came out yesterday, the answer is yes, that it could be more than the 3 credit hours that is the rule in a normal year. The guidance, as far as I know, does not specify how much more than 3 credit hours, just that it can be more than that and cannot be 100% online, as Emily was mentioning.
Amanpreet from Facebook wants to know, based on this USCIS furlough that's coming, is it advisable to upgrade to premium processing when you have an RFE response to submit? I think it's not a bad idea, because a month from now we might see processing times drastically increase. It might take your case even longer to get approved if you don't upgrade to premium. Normally it's a 60-day response time after you submit an RFE response, but that could go on and on for months. So if possible, it's not a bad idea to upgrade now before any furlough happens. Try to get your approval in place so that you don't have to worry about those long delays.
Amit Kumar from YouTube is asking a scenario that's been unfortunately pretty common this year and actually since last year. His H-4 EAD is expiring at the beginning of August. He hasn't even been scheduled for his biometrics yet because of the office closures, and is asking, is there any way for him to continue working until he can get the renewal? Unfortunately not. An EAD, if it is based on H-4 status, you're not authorized to continue working based on the pending I-765 application. So there are a couple of other types of EADs that do allow you to work based on the I-765 receipt notice, such as a pending OPT extension or an EAD renewal based on a pending I-485 application. But an EAD that is based on H-4 status does not allow you to work once your current EAD has expired. You need to wait until you have the new EAD in hand, until you're authorized to work again. He's also asking, can he go on leave without pay until the new EAD arrives? That is, I would probably speak to an attorney about that specifically, although we do get that question also. What you have to be careful about is even if you're not being paid, you definitely are not supposed to do any work for the company. And so you also, even if you're not doing anything, leave without pay, you have to be careful that there isn't still an employer-employee relationship there. So I would probably discuss specifics with an immigration attorney.
One of the questions from Apurv on Facebook is it common to get an RFE on an I-140 if you file it in premium processing? So in our experience, premium processing does not cause RFEs. So it's not the premium processing that is going to lead to getting an RFE on an I-140 petition. It's what's being filed. So if it is a weaker case or the documentation isn't all there, that's what's likely to cause an RFE, not the premium processing. I think there's a big myth out there that premium causes RFEs because the officers want to slow things down or they can't keep up, or all these different kind of myths. But in my experience, you're just as likely to get an RFE in regular versus premium processing. It's all depending on what documentation is being submitted.
So I've seen a couple questions asking whether, in light of the potential furlough, is it advisable to upgrade a pending application to premium processing now while it's still available? Yeah, that might be something that is prudent to do while there's still premium processing available for pretty much all applications this month. You can send in the additional $1,440 filing fee with the I-907 form. You do need the receipt notice. So if it's, for example, an H-1B application that was just filed last month, as a CAP subject application, it might be taking longer than usual to get just the receipt notice confirming that the application was received. That's pretty typical. We've been noticing the Vermont Service Center especially has been taking even 2 weeks sometimes just to cash the filing fee checks, and then it's another 2 weeks sometimes before we get the receipt notice. So if you're noticing that, that is pretty common right now. But once you get the receipt notice, you can send it in with a premium upgrade request to move it into premium processing, and USCIS is supposed to take action on the case within 15 days of receiving the additional fee.
Snehal from Facebook wants to know if you can work 20 hours per week while holding an H-1B temporarily for a short period, like 2 months. So it is possible to have a part-time H-1B, but before you can make that change from going from full-time to part-time, the company has to file an amendment. So that requires a new LCA and a new I-129 petition to be filed to reduce your hours, because that is considered a material change. So if that amendment is not filed and the hours are reduced and the pay is reduced, that could later lead to a potential wage and hour violation for the employer, because they didn't pay the salary listed on the H-1B petition. So definitely need to file an amendment to make a change like that.
So I've seen a couple of questions asking about what happens with H-4 visa appointments at the consulate that were scheduled maybe before the executive order came out that suspends anyone from applying for a new H visa at the consulates. Yeah, it looks like in some of those cases the fingerprints have been done, or the interview is scheduled for later in the summer, and what happens now in light of the executive order. Most likely the consulates, I believe, themselves will probably cancel the appointments. I don't think the applicants themselves need to take any action right now. The consulates are aware of the order and know that they can't even process H-4 visa applications right now. So most likely it will be canceled, and hopefully the order doesn't get renewed and that visa appointments can resume next year.
Sushmita from YouTube, she has a family member who recently got married and applied for the H-4 visa, but then the visa appointment was canceled, and wants to know, because of this executive order, is it possible for her to apply for an F-1 instead of an H-4? So technically it is possible, assuming that the consulate reopens to any visa appointments. However, you have to realize that the F-1 requirements to qualify are different than the H-4. The F-1 is not a dual intent visa, so the person has to be able to prove that they do not intend to stay for a long period in the U.S., that they'll return to their home country at the end of the program of study, that they have ties to their home country. That may be difficult to do when the spouse is in the U.S. in H-1B status. So yes, technically you could apply for it, but it's very possible that the visa might be denied on the grounds of intending immigrant to not give that F-1 visa.
I don't know if you've answered this already. Kushi from Facebook, who has an H-1B approved in consular processing. It looks like they're on an H-4 EAD right now and is asking about any issues on going to India for visa stamping. I assume you mean next year, because for the rest of this year at least, the executive order is suspending any new H visas, H-1B or H-4 or H-2B, from being issued from consulates overseas, unless the order is put on hold or lifted or barred from being implemented by a court order. Through the end of this year, consulates won't be able to issue any new H visas. So it looks like this person is on H-4 EAD until next year, so I would continue working based on your EAD and take a look at the situation next year. Hopefully the executive order is lifted by then and consulates are open and you can go for your H-1B visa stamping in India. There shouldn't be any issues as long as you've been maintaining your H-4 status in the US so far.
Yeah, the other option there, which requires the employer's cooperation, is to file a change of status from H-4 to H-1. It's basically filing the petition over again, but not subject to the cap because the employer's already got that approval. That can only be done if it's the same employer that received the consular processing approval, and the employer has to be willing to go through that whole filing process again. So some are not wanting to do that, but others might be interested in that so that you can keep your work authorization. Ravi from YouTube wants to know if we can still file perm labor certification and I-140s during all of this craziness that's going on right now. Yes, you can. So the perm process has not been impacted. No issues with filing that. And the I-140s are continuing to be accepted. Those can be filed in premium processing. Right now, if it's a perm labor-based petition. So those have not been impacted at this time.
Avinash from YouTube is asking if, in light of the executive orders, do green card holders have any issues traveling? So the answer is no, in light of, as far as the executive orders go. So far, all the executive orders have, for the most part, carved out exceptions for legal permanent residents, green card holders, so they are not subject to the suspensions or travel bans or anything like that. Do keep in mind though that anything health related is still in place and does affect green card holders. So closures on the US, Mexico, and Canada borders to non-essential travel are still in place through July 21st for now. Any travel restrictions to countries based on their health situation are still in place, and so keep those in mind.
Kind of along those same lines, Avinash, well, maybe, is this the one you just answered about permanent residents? Sorry. Let's see, Vijay from Facebook has an expired H-4 EAD, but the extension is pending and wants to know if someone who is a business owner in that situation can continue running the business. Unfortunately, no. Without that work authorization, any work you're doing to run the business is considered unauthorized employment. So you may have to hire someone to run the business for you temporarily until you get the EAD back.
A note from YouTube is asking about a situation where he was laid off from his H-1B employment earlier this year, it looks like, and filed a B-2 change of status application, which a lot of people in a similar situation have been doing this year in light of the COVID pandemic. It looks like he has found a new job opportunity now and is asking if an H-1 transfer can now be filed while the B-2 change of status application is pending. So that is pretty tricky. It depends a lot on whether I think you are still in the 60-day grace period. So the 60 days that starts from when you were initially laid off from your H-1B position previously. You have a 60-day grace period during which if an H-1B sponsor files a transfer for you, it's not considered late. If you are still in that 60-day grace period, I think the transfer could be filed without a problem, and you would go ahead and withdraw the B-2 application because it's no longer needed. If you are past the 60-day grace period, it's much more difficult to file that transfer. For one thing, since you're past the 60-day grace period, you're out of status. Depending on how far you're past it, the nunc-pro-tunc argument that we have used sometimes in the past may not be feasible. And as we've said during these sessions also, it's not really possible to change status from B2 back to H1B. The B2 in a normal year is really not an option. It's not something we've done or have advised people to do at all until this year, and it's only because of the health situation. It's really in a situation where your intention is to depart the US, but you physically cannot because you cannot get a flight, or the borders to your home country are closed, or you have a health or medical situation. So those are the only situations where people are filing B2 applications, and so in that situation you can't really change back into H1B. I would say if you're past the grace period, probably the only thing you can do right now is to maybe have that new company file a consular processing application for you and see if you can possibly go for visa stamping next year when the executive order is lifted and when the consulates reopen.
Ron from YouTube wants to know if we're planning to do the H4 EAD litigation again. We have a lot of people who, because of the biometrics and the long processing times, the H4 EADs and the L2 EADs are getting expired while they're waiting for the I-539 to process, and they have to stop working. So a lot of people are in that situation. We do want to start the litigation again, filing these delay cases to get the process done in a reasonable period of time. However, the COVID-19 situation has impacted our ability to do that. We have to wait on some decisions on some current cases that we have pending, where we've made some arguments regarding the really unnecessariness of the biometrics requirement. So until we get decisions on those, we don't want to continue filing if we're not able to provide an actual expedited EAD renewal. So we are hopeful that we will be able to, but not at this time.
Pratyusha from YouTube asked a good question of whether we expect any litigation to be announced or filed against the announcement from yesterday from SEVP. And that has been, in the news. People discussing this new rule are already discussing the likelihood of a lawsuit being filed, because it is, as a lot of people in the comments have pointed out, it's really an unfair rule. It's a really bad position to be putting not only the students but the universities to, force them to put at risk not only the international students' health but the health of their whole student population by, trying to force them to open in-person classes or even a hybrid model when the situation in their state may not, that may not be in the best interest of the students and faculty. So there are a lot of problems with with this announcement. And so hopefully there is a lawsuit that's filed to possibly put on hold the implementation of this rule. If so, it would need to go into effect pretty quickly also. I don't know, do you have any thoughts?
Yeah, I would expect there's got to be some schools that are going to fight this, because it's just, you know, they're, like you said, they're forcing schools to choose between their students' health and having international students on campus, and with such little time available. So hopefully we will see that happening soon, and maybe they'll be able to get a injunction to block it going into effect. Abhishek from YouTube wants to know if there are any other upcoming executive orders that we know about that might be targeting existing visa holders in the U.S. Well, I mean, we can say one thing about the Trump administration is they're very unpredictable. So, you know, sometimes these executive orders pop up out of nowhere based on whatever happens to be going on in the news in a given media cycle. At this point, I don't think there are any planned executive orders that will target existing visa holders inside the U.S. What we do expect to come is new regulations that might impact existing visa holders in the U.S. specifically. And again, we don't have specifics. It's just the last executive order directed the Department of Homeland Security, Department of Labor to ensure that the U.S. workers are not impacted by continuing extensions of H-1B visas, for example. And so what some people have interpreted that to mean is maybe they're going to have some sort of ongoing labor certification process for people to receive their 7th-year extensions beyond the 6-year limit under AC 21. That's simply a guess at this point. I think it's a pretty good guess based on the language and the part of the statute that they're referring to. Whether it's going to be an actual ongoing labor certification, or maybe it's just some kind of attestation a company has to make on an LCA before they can file that extension, nobody really knows. And with the Trump administration, one thing we see time and again is they kind of float these different ideas out there that sound really bad, and wait to see what the impact is, what the reaction is, and then when the actual order, the actual regulation comes out, it's much different than what everyone was speculating or what has been leaked previously. So I would just say that it sounds like plans are in the works to make some changes for extensions, but it has to go through the regulatory process, and whatever they're planning right now may be very different than what actually comes out. So I try not to panic about that at this point.
Nitanj from YouTube is asking about his green card process. It sounds like his I-140 is approved, but he is not working for the I-140 petitioner currently, and is asking what happens if his priority date becomes current. As we've kind of discussed in the past, there's the potential, possibly later this fall, for priority dates to have forward movement in the EB India categories, as sort of a unexpected side effect a bit of the executive orders, that there will be unused green cards in especially the family-based category for this year, that will spill over into the employment-based category for the next fiscal year that starts in October. So we don't know how much, or to what extent priority date movement might go forward, but if Nitanj's priority date does become current, so it's not a firm requirement that you be working for the company that filed your I-140 petition. However, when you file the I-485 application, even if you're not working for that company needs to provide an I-485J supplement, which is their statement that they still have this job offer open for you. So because the green card position is technically a future position, it's not absolutely required that you be working for that company at the moment, although it most commonly is that case because most companies are not willing to provide that statement of an open job offer unless you are currently working for them. So if the company is not willing to provide you with that I-485J supplement statement, you will need to find another employer to basically start the perm and I-140 process for you again so that you have a job offer there to support your I-485 application.
Prashant wants to know, in the situation where the H-4 I-94 has expired but the transfer is in progress, how long can the person stay in the U.S.? So I'm assuming that you mean the H-1 transfer is in process and you also filed an H-4 extension along with it, and that's pending, and the H-4 I-94 has expired while it's pending. So assuming I'm correct, then the H-4 applicant who's got the extension pending can remain in the U.S. the entire time the H-4 application is pending. So you don't have to worry about that I-94 expiration as long as the H-4 extension was timely filed before it expired.
Ramya has a question about whether an amendment is necessary for an H-1B visa holder if you're working remotely from home. So that's becoming more and more of a common situation with everyone working remotely. If your home is in the same metropolitan area, Ramya, as your approved LCA, it's the work location identified in the LCA in your approved application, then an amendment isn't necessary. The LCA covers the entire metropolitan statistical area, and so you're authorized to work from home. The company doesn't need to file anything additional as long as there aren't any other changes in your job duties, hours, or title that would require an amendment.
Harish from Facebook wants to know if there's any chance of amending the June executive order to waive off the ban on dependent visas. So, you know, I don't think there's a high likelihood of the executive order being amended willingly by the Trump administration. Where I see a possibility is if lawsuits are filed and a judge finds that the purpose of the executive order is not being served by blocking dependent spouses and kids from coming into the U.S., then we might see changes to the executive order. So, you know, the main argument behind implementing the executive order is we have so many Americans out of work, we should not be bringing in people from other countries to do the work. We should give those jobs to Americans. But if that's the real reason for blocking the entry of people, why would you be blocking the entry of kids? They're clearly not coming to take away our jobs, and spouses, not all of them have EADs, many of them don't, and they're not able to come to take away our jobs. So if we get some positive results from litigation, then we might see that policy change.
Sort of related to that, Subra Prating from Facebook is asking if H-1 and H-4 visa holders with U.S. citizen children can go for stamping. So the executive order did list some exceptions. Obviously, it doesn't apply to U.S. citizens. So U.S. citizen children are not barred from entering the U.S. at all. They can still enter the U.S. as citizens. Whether their parents who are in H status are able to apply for a visa to accompany them, I think is less clear. There isn't anything, I would say, in the order that guarantees that you will be able to apply for an H visa at a consulate for the purpose of accompanying your U.S. citizen children into the U.S. If your entire family is outside the U.S. right now, unless there is some other extenuating situation like a medical or health situation, or unless your job is in an essential industry or in an area of national importance that would warrant an exception from the consulate. Barring that, I would say that just the fact that your children are U.S. citizens, I don't see the consulates or the government right now really granting an exception in that case, unfortunately.
Purnachandra from YouTube recently received an H-1B extension approval, but it was consular processing based on an I-140 approval that happened after the 6-year limit was reached, and wants to know if this executive order will affect the visa stamping if you go out of the country to get the visa at this point. Unfortunately, it will. Because it is going to be a new visa stamp that's required for that approval notice that you received. I think that you won't be able to receive it until after the executive order is lifted. So if you're currently in the US in some other status, your employer could possibly file another H-1B to request a change of status this time around. That would be one other option there.
Okay. Parag from Facebook has notified us of, says that just in, Congress plans a new funding bill to aid the USCIS shortfall. Yeah, that might have just come in, while we've been here in the past hour. So that is good news. Hopefully that is the case, and that an agreement will be reached, before August 3rd to kind of give some certainty to not only the USCIS employees, but everyone who files applications with USCIS. So hopefully that is the case and that it goes through.
Cheng Liu from Facebook wants to know how long it takes USCIS to respond after an RFE. So generally, if it's a regular processing case, their normal processing time is about 60 days after they receive the response to the RFE. If it's premium processing, they have to respond within 15 calendar days of receiving the RFE. If it goes beyond the 60 days, probably more like beyond 90 days, your employer may be able to submit a service request, or their attorney, for a case being outside the normal processing time. But generally, it's about 60 days right now.
So we've seen some questions on when the consulates in Canada may start accepting appointments again, especially for F-1 visa appointments. I think I've seen a couple questions on that. So there hasn't been any across-the-board announcements from the State Department on when consulates will start reopening to the public or start scheduling interviews again. It does seem to be very much a consulate by consulate determination based on the local health issues in that area or in that country. So as far as I know, I haven't heard of individuals being able to schedule consular appointments in Canada just yet. We know that for the most part, the consulates in India are still closed to the public except for some emergency situations. We have had some clients successfully schedule visa appointments in Mexico for the end of the summer, I think in August. So it seems like there isn't any announcement really from the State Department or consulates. It seems like it's more of a case of just checking on that consulate's website and seeing if they are opening up appointment availability, and so it may just be a lot of checking the website over and over, unfortunately.
Had a couple of questions about what happens to an I-140 if the person leaves the country, either while it's pending or after it's approved. What happens to the green card process at that point? So the whole basis of the green card is that the U.S. employer has a job offer available for the person they're sponsoring. It's a permanent job offer, and the employee intends to take that job when they receive their green card. So it is possible for someone to be outside the country and still have the green card process going on and still receive the green card if that job offer continues to exist. So it does take the cooperation of the employer. So, if you come back into the U.S. by the time your priority date is current, you may be able to file the adjustment of status, but you have to have that supplement J submitted by the employer, as Rebecca was talking about earlier. If you're still outside the U.S. when the priority date becomes current, then you would consular process your green card application through the consulate versus coming into the U.S. But that I-140 itself, if it's already approved, it generally remains valid until the employer withdraws it. But to actually receive the green card, the job offer still has to be there.
So Bhuvana from YouTube, it sounds like she's in F-1 status, working on an OPT, and her H-1B application is pending. So I assume it's a CAP subject application, and she's asking if she can travel to India due to some emergency. So it depends a lot on how the application for H-1 status was filed. Most likely it was filed requesting a change of your status from F-1 to H-1B effective October 1st. If that's the case, that your H-1 application requests a change of status and it's pending right now, if you leave the country, that application for the change of status portion is going to be considered abandoned. So the application for H-1 classification can still be processed. USCIS can still determine, whether your job is in a specialty occupation, whether you have the required qualifications for that job, and so they can still issue an approval notice for H-1B classification, but it would not have the I-94 attached to the bottom of the approval notice that changes your status, because once you leave the country, USCIS can't change your status if you are not here in the U.S. to have your status changed. So you have to be really careful. In a normal year, something like that wouldn't be as much of an issue, because what you would do in that situation is then take that approval notice, go for visa stamping, and come back in October to activate your H-1B status, basically. Everything is different this year with, first of all, the executive order. If it is still in place in October, that's going to prevent you from getting the H-1B visa stamp, on top of the fact that consulates in most places are still closed, and so even in the absence of the executive order, you may not be able to get a visa appointment. So Bhuvana, I would recommend that you discuss your situation with an immigration attorney. I understand if it's an emergency situation and you have to travel, but just be aware that if you do leave the country this summer, you may not be able to come back in H-1B status until next year.
A couple more questions on the new F-1 visa restrictions on online courses. Robbie from Facebook wants to know if someone could stay in the U.S. and file a change of status to B2 in order to stay in the country. So yes, if your F-1 is going to be ending because your school is only offering online and you don't have the option of switching to another school, you could file a change of status to B2. It has to be filed before you lose your F-1 status. And note that you can only ask for a 6-month stay on the B2. So it's not a great long-term option, but it is some way for you to continue to stay in the country while you wrap things up and try to get travel arrangements to return home. Another question from Shashank on Facebook. If the parents are currently in the U.S. on L1, but the child is on F1, can the child convert to L2 in order to avoid the issues with the F1 visa? So assuming that the child is still under 21, yes, that is possible to file a change of status from F1 to L2 while the person stays in the U.S. They have to file it before losing the existing F1 status.
So we are still getting other questions about when embassies overseas might be reopened. As we said before, it will really depend on the individual consulate. So especially in India, it sounds like there aren't any visa appointments being accepted right now.
All right, I think we're just about out of time. I'll try to take one more here. This is from Dharmendra on YouTube. Recently got his H-1B extension approved. His wife is in India, and she has a valid H-4 until September. But the attorney was planning on withdrawing the H-4. So I'm guessing that an H-1 and H-4 extension were filed. The H-1 is now approved. The H-4 extension is still pending because of the long I-539 processing. But then while it was pending, your wife went to India planning to get the H-4 stamp. Well, if her current visa has not yet expired, she can come back into the U.S. By September in order to get back into H-4 status, but you still need the H-4 extension in order to be approved to stay beyond that date, because when she's coming in, she's only going to be given the time till the current H-4 visa expires. So hopefully I got the facts right on your situation. She should be able to come in using the existing visa, but it sounds like an extension is still going to be needed. All right, I think we're about out of time, so thank you for joining us this week. Lots of crazy things going on, it seems like, in this kind of new unprecedented times. We'll be back next week on Tuesday at 5 o'clock Central Time. In the meantime, remember that we do have a free daily conference call where you can join in to get your questions answered. The schedule and dial-in information is on rnlawgroup.com, and you can also go to our website, rnlawgroup.com, to schedule a consultation with Rebecca, myself, or any of our other attorneys here at Reddy & Neumann PC. Thanks for joining us today.